Good afternoon, everyone. I'm Angela Nwachi-Willig, Dean of Boston University School of Law, and I want to welcome you to our 2025 Kleh International Law Lecture. Today's lecture is made possible by William H. Kleh and Patricia Kleh. Bill is a graduate of BU Law's class of 1971, and years ago, Bill and his wife Patty made a generous gift to establish the William and Patricia Kleh Visiting Professorship in International Law and to support this lecture series. So we're very lucky that Bill and Patty are here with us today. If you could stand so we can embarrass you just a little bit. We're delighted to be able to extend a warm BU Law welcome to you and to express our very sincere gratitude to you for your contribution, very generous contribution. International law is a critical subject for any aspiring or practicing attorney in the 21st century. We are living in an increasingly global society, and the accelerating trend towards globalization is certain to continue. Globalization is not simply about economics. It also concerns environmental justice, prosecutorial ethics, human rights, and as Professor Enrique Prieto-Ríos will explore in his lecture, it is also about the importance of developing sound guiding principles to ensure accountability and address corporate complicity in global violence and inequality. As Bill and Patty Kleh have long recognized, because of the impact that international law has on all of our lives, it's critical that we all seek greater education about globalization and international law. Even if an attorney plans to practice only in the United States throughout their entire career, knowledge of international law is important to a holistic understanding of the law and to civic engagement in our global community. These interconnections within our global society are what make the Kleh Lecture on International Law so important. Since the lecture was first established in 2011, we at BU Law have welcomed legal scholars from around the world to discuss tort litigation against state sponsors of terrorism, the legality of torture and enhanced interrogation methods, victims' rights in international criminal law, income inequality, citizenship, crimes against humanity, regional activism and criminal reforms, and many, many other important topics. We are extremely grateful to the Klehs for providing our students and our entire BU Law community the opportunity to engage with esteemed scholars of international law on these topics. Today's lecture involves the 8th Kleh visiting professor, whom I've had the honor of hosting since I became dean, and like the others, I've been anxiously awaiting this lecture. It's an event that I look forward to every year, and we've had the good fortune of hosting many excellent scholars as a Kleh visiting professor. And this year, it is my honor to introduce the community to our 2025-2026 visiting professor of international law, Enrique Prieto-Ríos. Professor Prieto-Ríos is an academic researcher and a legal consultant specializing in public international law, international economic law, human rights, global value chains, and decolonial and transformative constitutionalist approaches. He currently serves as associate professor at the Faculty of Law at Universidad del Rosario and the chief editor of Estudios Sociojurídicos, an esteemed academic journal. Professor Prieto-Ríos' articles and books have been published by or will be published by publishers and journals like the Oxford University Press, Cambridge University Press, Springer, the Leiden Journal of International Law, Business and Human Rights Journal, and Law and Critique, among many others. He also has contributed chapters to collective volumes, including the Oxford Handbook of International Law and the Americas, and the Cambridge Handbook on Investment Law and Human Rights. And he is co-editor for several forthcoming volumes on critical approaches to international law and corporate accountability. He has previously served as research director for the Faculty of Law and head of the research group on international law at Universidad del Rosario. And he also has been a visiting research fellow at prestigious institutions, including the Max Planck Institute for Comparative Public Law and International Law, Osgood Hall Law School at York University, and the School of Law at the University of Warwick. Additionally, he has taught at the Universidad de los Andes and served as a sessional lecturer at Birkbeck University of London. His expertise extends beyond academia to policy and legal consultancy as well. For instance, he advised the Presidential Counselor for Human Rights and Foreign Affairs on Colombia's third National Action Plan on Business and Human Rights. He's also provided strategic human rights guidance to Colombia's Ministry of Justice and the Ministry of Defense, and he has worked with organizations such as Panagora Group and the International Committee of the Red Cross on international humanitarian law practices in Colombia. Since 2019, Dr. Prieto-Ríos also has served as a commissioner on Colombia's Advisory Commission on Peace and Human Rights. Earlier in his career, he directed the British and Colombian Lawyers Association and clerked at the Colombian Constitutional Court. And because of the dear professor here, we'll have a Colombian Supreme Court justice with us here tomorrow. He holds a MA in International Law from the University College London and an LLB from Universidad del Rosario. He received a PhD in law from Birkbeck University of London, which connects him to one of our previous Kleh visiting professors, Dr. Eddie Bruce Jones, who previously served as Deputy Dean and then the Dean of the Faculty of Law at Birkbeck University of London, and who now serves as Dean of the College of Law for SOAS University of London. We just love to see these global connections between such stellar international law scholars, and we're delighted to once again benefit from this very impressive network of scholars. So please join me in giving a warm welcome to our Kleh visiting professor of international law, Enrique Prieto-Ríos.
Okay, so can you hear me? Yeah, thanks. Okay, so good afternoon, everyone. Let me begin by expressing my deepest gratitude to Dean Angela Nwachie-Willig, to William and Patricia Kleh, and to BU Law for the honor of serving as this semester's Kleh Distinguished Visiting Professor and for the privilege of delivering today's lecture. My time at BU has been profoundly meaningful, both professionally and personally. And this is an experience I will carry with me for many years to come. I am sincerely grateful to my colleagues here at BU for the conversations, collaborations, seminars, and debates that have shaped my thinking over the past months. I want to extend a special thanks to those who have opened their homes to me and my family. Your generosity made us feel truly welcome. To my students, I see some of you here today. Thank you for your curiosity and engagement. Teaching you has been one of the highlights of this semester at BU. And finally, many thanks to my wife, Diana, who is sitting over there, and our children, Tomas and Helena, for being here with me throughout this journey. Just as my family supported me throughout this semester, my colleagues here at BU also supported me while I wrote this work in progress paper that became today's lecture. What began as a loose idea eventually became an abstract, and little by little, it became a full manuscript. I want to thank Erica George for your thoughtful comments on the early abstract, Aaron H.C. Black, who is over there, for helping gather some important documents and academic literature. Jack Bierman, thank you so much for reading the full draft of my paper and offering feedback that I think strengthened my arguments. And finally, Rebecca Pendleton, thank you so much for your comments that I think helped me to improve, or I hope so, to improve today's presentation. As I wrote and rewrote this paper, the title of this reading of this conference changed several times. Eventually, it came to settle into what you see here, from Chiquita to the UNGPs, systemic violence, and the colonial architecture of international business and human rights framework. This is still a work in progress. So I very much look forward to your comments and questions, which I am sure will help me to strengthen the arguments of these papers. Today's lecture is divided in three main sections. First, the Chiquita paradox. Second, structural changes in the business and human rights framework. And third, what a colonial approach to business and human rights might look like. Let me begin with the Chiquita case. On June 10, 2024, a jury in the Southern District of Florida delivered a historic verdict against Chiquita Brands International, ordering the company to pay $38.3 million to the families of 8 Colombians that were murdered by Autodefensas Unidas de Colombia, AUC, a paramilitary organization that was designated by the government of the United States as a terrorist organization. This was the first time in US history that a jury held a US multinational corporation liable for human rights abuses committed abroad, relying on a very old doctrine, transitory tort doctrine. How did we get here? Well, to understand this outcome, we need to take a step back and briefly trace Chiquita's long and complicated presence in Colombia. Chiquita's connection to Colombia dates back to its predecessor, the United Fruit Company, which arrived in Colombia in 1899. Throughout the 20th century, the United Fruit Company became a dominant economic and political force in Colombia. It controlled ports, railways, plantations, and labor markets, shaping not only local economies, but also governance itself. Its influence was so extensive that it gave us the now famous term, banana republics. This phrase captures how deeply a single US corporation could shape the political and economic life of entire nations. In 1928, Colombia witnessed what is now known as La Masacre de las Bananeras, the Banana Massacre. In Ciénaga Magdalena, security forces opened fire on thousands of striking banana workers who were demanding basic labor rights. The exact number of victims remains unknown, but historians estimate that hundreds were killed. Gabriel Garcia Marquez, Colombia's Nobel Prize, immortalized this tragedy in his masterpiece, 100 Years of Solitude. This massacre is a clear example of how corporate and state power can merge, allowing economic interest to prevail over human life. United Fruit Company became United Brands Company in 1970, and later in 1990, the company adopted the name Chiquita Brands International. And if you go to Trader Joe's or Target, you'll find the Chiquita bananas. Chiquita left Colombia in 1982 because the escalation of the domestic conflict that at the time involved guerrilla groups, paramilitary groups, and drug cartels. However, it returned in 1981 to Colombia through its subsidiary Banadex. In 2001, the US government formally designated the AUC paramilitary group as a foreign terrorist organization. But despite this designation, evidence later showed that between 1997 and 2004, Chiquita, through its Colombian subsidiary, paid more than $1.7 million to the paramilitary group. Internal records and court filings revealed that in 2003, the company's external legal counsel had explicitly advised the company against these transactions because, of course, that violated international law and US law. And of course, as you can imagine, these monies serve to indirectly finance massacres, forced displacement, torture, and mass displacement in Colombia. Chiquita later reported its own conduct to the US Department of Justice, triggering a federal investigation. Subsequently, the company pled guilty to one account of engaging in transactions with a specially designated global terrorist in violation of Executive Order 13224 and the International Emergency Economic Power Act, IEPA, very famous nowadays, which prohibits US entities from financing designated terrorist groups. Chiquita was fined $25 million and was placed on probation for 5 years. But that penalty did not mean justice for the Colombian victims. The company went so far as to repatriate its foreign personnel to the United States, shielding them from potential criminal prosecution by Colombian authorities. In the years that followed, Colombian government tried to obtain the extradition of several US-based Chiquita executives that were implicated in authorizing the payments to a paramilitary group. However, those requests, as you imagine, were unsuccessful. It only reflects the enduring jurisdictional and diplomatic asymmetries that often protect corporate actors operating across borders. When Colombian victims tried to seek justice at home, they faced real threats and retaliation from the paramilitary groups. Bringing cases against corporations connected to armed actors was, and in many regions still is, extremely dangerous in Colombia. For this reason, the families harmed by the paramilitary group, which we know Chiquita had partially financed, were left with what was essentially their second best option: filing civil lawsuits against the company in US courts. Several of the cases were filed under the Alien Tort Statute, ATS, against Chiquita, but they were dismissed after the Supreme Court's decision in Kiobel v. Royal Dutch Petroleum 2013, which, as many of you know, limited the ATS extraterritorial reach. Courts also dismissed claims under the Torture Victim Protection Act, relying on the case of Mohammed v. Palestine Authority 2012, where the Supreme Court held that TVPA applies only to natural persons, not to corporations. This brings us back to the transitory tort doctrine. The transitory tort doctrine allows a US court to hear a case involving a civil wrong or tort that occurred in a different jurisdiction and was caused by a US citizen or corporation. This doctrine is applied in both interstate and international contexts to provide a legal remedy when one is otherwise unavailable. This doctrine comes from the English courts, and its most famous precedent is the case of Mosting v. Fabregas, 1774. In that case, a resident of Minorca, what was at the time a British colony, filed a lawsuit against the island's governor, accusing him of trespass and unlawful detention. Because of colonial regulations, this lawsuit requires the governor's consent before the victim could file the legal claim. Hence, the claimant pursued the case before a London court, miles away from Minorca, and he was awarded £3,000 as compensation. In the United States, this doctrine evolved as a jurisdictional tool allowing courts to hear torts committed in other states or abroad. In two key decisions, Mitchell v. Harmony, 1852, and later v. Mexican National Railroad Code, 1904, U.S. courts reaffirmed this doctrine by agreeing to hear cases involving harms that happened outside the United States while applying foreign law of the place where the injury happened. This is why when Chiquita tried to dismiss the case on the basis of foreign nonconvenience, the U.S. court rejected that argument. The judge recognized that sending the plaintiffs back to Colombia was simply not a realistic option. It would have placed them in immediate and very real danger. The jury in the Southern District of Florida ordered the company to pay $38.3 million to the family of 8 Colombians murdered by the paramilitary group. And although the case took place in Florida, it was actually decided under Colombian law. The jury applied Articles 2341 and 2356 of the Colombian Civil Code, which establishes liability for damage caused by a wrongful or negligent act. This verdict was a victory because after so many years, justice was finally delivered to the victims. However, we arrive at the paradox I mentioned at the beginning. The harm, the violence occurred in Colombia. The victims were Colombians. The law applied was Colombian tort, and yet accountability came only through a US court using an 18th century doctrine originally developed in the context of British imperialism. So what does the Chiquita case reveal about global accountability? Well, first, it shows how weak corporate accountability remains when abuses happened outside powerful jurisdictions. Second, it exposes the structural imbalances that make it difficult to require companies to respect human rights in practice. And third, it highlights the urgent need for a stronger and clearer business and human rights framework. And this brings me to the second part of today's presentation, a closer look at why the current global framework on business and human rights is still falling short, and why it often fails to deliver a real accountability and justice. Next year will mark the 15th anniversary of the UN Guiding Principles on Business and Human Rights, developed under the leadership of Harvard professor John Ruggie. These principles offer a global framework for addressing business-related human rights abuses. The UNGPs have 3 main pillars. First pillar, the state duty to protect. Second pillar, the corporate responsibility to respect. And third pillar, access to remedy. Following the adoption of the UNGPs in 2011 by the UN General Assembly, a wide range of instruments have gained traction among governments and companies. Let me briefly highlight three of the most significant ones. First, national action plans. NAPs are policy frameworks that governments use to explain how they intend to implement UN guiding principles on business and human rights. In simple terms, a NAP sets out how the state will fulfill its duty to protect people from corporate abuses, how it will encourage companies to respect human rights, and how it plans to ensure access to remedy when harm occurs. According to recent data, roughly 30 to 35 countries have adopted national action plans on business and human rights, including, most recently, the United States in 2024. This shows real global momentum. But in practice, the impact of NAPs has been rather limited. Most of them are not binding, they lack enforcement mechanisms, and they often fail to include meaningful participation from affected communities or civil society. The second instrument I want to refer to are the national baseline assessments on business and human rights. MBAs examine how effectively the state and corporate actors are implementing the business and human rights framework. It also identifies regulatory gaps, incoherences, and institutional weaknesses that hinder the protection of human rights from corporate-related harms. According to available data, around 60 national baseline assessments are either underway or have already been completed around the world. However, despite their value, NBAs often struggle with limited funding, inconsistent methodologies, and weak follow-up. As a result, many of the recommendations stay in paper instead of being translated into concrete actions. The third instrument I'd like to turn to is human rights due diligence. Human rights due diligence requires companies to identify, prevent, mitigate, and account for human rights impacts connected to their operations. Yet, implementation remains extremely limited. According to a World Benchmarking Alliance, in 2024, only about 6% of the world's 2,000 most influential companies implemented human rights due diligence. And even among those companies, due diligence is often approached by some as a narrow compliance exercise, something to document and report rather than as a transformative process capable of reshaping business practices or addressing structural harm. It is important to note, however, that the UNGPs stop short of articulating an explicit framework for human rights due diligence in conflict-affected countries or areas like Colombia. To fill this gap, the UN Working Group on Business and Human Rights developed the notion of heightened human rights due diligence for companies operating in conflict-affected areas. Accordingly, the heightened human rights due diligence requires businesses to consider how their operation may exacerbate or benefit from conflict dynamics. In these high-risk settings, neutrality is impossible. Corporate presence can directly influence patterns of violence, governance, and inequality. In addition to the weaknesses already mentioned in the business and human rights framework, there is another deeper structural problem. The entire framework has largely been shaped through global north perspectives. As a result, it does not fully reflect the realities and challenges of the global south, including internal armed conflict, widespread informality, and limited access to justice. And because the framework is voluntary, it also has a major limitation, It encourages companies to act responsibly, but it does not require them to do so. At the same time, while business and human rights framework remains voluntary for corporations, another branch of public international law imposes binding obligations on states to protect corporate interests. That branch is international investment law. International investment law is built on more than 3,000 treaties around the world that regulates how states must treat foreign investors. Those treaties include several protections, including safeguards against direct and indirect expropriation, include standards such as the most favored nation, fair and equitable treatment, and umbrella clauses, among others. International investment law includes a mechanism known as Investor-State Dispute Settlement, or ISDS. This mechanism grants corporations the possibility to, first, sue states directly before international tribunals. Second, it allows them to bypass domestic courts entirely. And third, it allows them to obtain multi-million-dollar awards from host states. The average amount demanded by investors in ISDS claims is about $1.16 billion. And the average cost of defending one case is around $4.7 million. These figures alone show how heavy the financial pressures on states can be. But beyond the financial burden, arbitral jurisprudence reveals a deeper structural problem. In situations of conflict or political instability, investment tribunals often issue decisions that constrain a state's ability to regulate, even when the government is trying to manage complex security, humanitarian, or other types of crises. Let me briefly highlight 3 arbitral awards that illustrate this dynamic. First, in the case of Patechniki v. Albania, 2009, the tribunal acknowledged that the country's political instability was happening, but still found Albania internationally liable for not protecting the investor rights. The second case is Bear Creek v. Peru, 2017. Here, the tribunal awarded damage to the foreign investor, even though the company's own failures, specifically its lack of meaningful consultations with the Aymara communities, contributed directly to the social conflict. And more recent cases involving investments in Crimea and eastern Ukraine have gone even further. Some tribunals have extended treaty protections into territories under occupation, applying the principle of effective control. In the case Stabili LLC v. the Russian Federation, 2015, the tribunal concluded that Russia was liable under the Ukraine-Russia bilateral investment treaty because it exercised de facto control over the territory that still is considered by international law as part of Ukraine. The way international investment law operates has also produced a phenomenon that many experts refer to as regulatory chill. This happens when governments hesitate or even refrain from adopting new public policies because they fear being sued by foreign investors before international arbitration tribunals. Faced with the risk of multi-million-dollar awards and costly litigation, governments may be discouraged from taking actions that could affect foreign investors, even when those actions are essential for public health, environmental protection, climate policy, or to deal with internal armed conflicts. In the case of Colombia, my home country, Colombia has 19 investment treaties and is facing around 26 investor states claims. This legal landscape does not operate in the abstract. It actively shapes how the Colombian government behaves. A striking example comes from a land restitution case connected to internal armed conflict. In the case La Larga Tumaradó, the Colombian Land Restitution Unit explicitly acknowledged that it changed its legal strategy to avoid the risk of provoking an ISDS claim, even though the mining concession at issue had clearly violated the community's rights to prior consultation. This is regulatory chill in action. The fear of being sued by a foreign investor was enough to shape how a Colombian public agency pursued justice for an ethnic community whose lands had been taken during the conflict. To wrap up this section, let me underline the structural contrast that emerged from everything we have just discussed. On one side, international law provides corporations with strong, binding, and enforceable protections when they act as foreign investors. On the other side, when these very same corporations cause harm through their business activities, the global framework relies on non-binding soft law standards that simply encourage companies to respect human rights. This imbalance is not accidental. It is built into the very architecture of international law. And now I want to move to a third and final part of my presentation, and to a question, what would a colonial approach look like? In many ways, the Business and Human Rights Project reproduces the structural problems already existing in international law. It was developed mostly by communities of practice based in the global north, and therefore shaped by their own priorities and assumptions. Second, it relies heavily on voluntary corporate compliance. Third, it translates structural injustices and human rights violations into issues of risk management. And finally, it treats global south realities such as informality, violence, precarious labor, not as structural conditions that demand transformation, but as issues that must simply require to be managed. The language of governance, stakeholder engagement, and due diligence ultimately leaves it to companies themselves to decide whether and how they will respect human rights, especially in conflict-affected areas. At the same time, a state's ability to regulate corporate conduct is often constrained by international investment law. In this context, the colonial thinkers, such as Frantz Fanon, whose 100th birthday we mark this year, remind us of something essential. Violence in conflict zones is not an exception to a globalized capitalist system. It is one of its products. Imagining an alternative approach to business and human rights requires a decolonial turn, one that challenges the current dominance of corporations in international law and rebalances whose voices, whose experiences, and whose harms are taken seriously in shaping international legal obligations. There are two initiatives that could, if strengthened, help move the business and human rights framework towards a more decolonial architecture. First, the UN legally binding Treaty on Business and Human Rights, which has been from the very beginning an initiative led by countries from the Global South. This proposed treaty aims to transform the UNGPs' voluntary standards into binding obligations. Its 11th draft expands jurisdictional bases, strengthens victims' rights, and clarifies forms of corporate liability. But the process remains politically complicated, especially because countries from the global north prefer soft law approaches and resist any instrument that will impose direct obligations on states or on corporations. Yet, this position is precisely what reveals the treaty's decolonial potential. It is being driven and led by countries from the global south, who in doing so are actively challenging the global north monopoly over knowledge production in international law. Second, the proposal for an international tribunal on business and human rights. This initiative, which first emerged in 2014 after a symposium at UCLA School of Law, deserves renewed attention. It offers an alternative institutional pathway, one that could represent a truly decolonial shift in how we address corporate responsibility for human rights violations. Unlike the current reliance on domestic courts or arbitral forums dominated by the North, a reimagined version of this tribunal could create a transnational space for justice, one where victims of corporate abuses, especially in the global south, can find remedy before an independent international tribunal. In 12 terms, there were approaches to international law terms. Such a tribunal would reclaim law as a tool of resistance rather as domination. A reimagined version of this proposal could do several things. First, ensure plural judicial representations with judges from different parts of the world. Integrate indigenous and other non-Western epistemologies into how evidence, harm, and responsibility are understood. And place clear, enforceable accountability on corporation. In practical terms, this will allow victims to seek justice without depending on foreign courts or colonial doctrines, and instead access a forum designed with the realities in mind. Let me close by returning to the Chiquita case. My intention today has not been to critique that judgment, because for the families who fought for years, that decision represents justice. But the architecture that made this justice possible, a colonial doctrine applied by a foreign court in the global north, reveals how the global legal order continues to operate through hierarchies of inequality. My invitation is to reflect in how we can decolonize the business and human rights framework so that it can actually deliver effective justice, especially to victims of corporate human rights abuses in the global south. Thank you very much. Yeah, so if there are questions, comments, yeah, I know how to.
Enrique, this was such a wide-ranging and informative discussion, not just legally, but also historically and theoretically. So thanks so much, and it's been a pleasure to have you here this semester. We've talked offline about social theory and our mutual interest in Gramsci and hegemony and these sorts of questions. Given that the problem you're putting your finger on correctly is that this is a combination of global North power and corporate power. The headwinds here are so strong. I want to go back to actually where you finished with regard to the litigation in Florida. How do you think about or how should we think about the total universe of smaller attempts to curb some of these corporate some of this corporate action, and I'll give you two more concretely that I might add to the Transitory Torts Doctrine. One is Foreign Corrupt Practices Act prosecutions. So when I was at the Department of Justice, we were thinking a lot about the FCPA. Some people see this as one of the only tools that can impose corporate liability abroad, but others would say, actually, this is just an extension of global north. Cowboy prosecutors trying to impose their notion of accountability on corporations abroad. The other one is, how should we think about rule of law initiatives, for example, in Colombia specifically? So correct me if I'm wrong, but my understanding is, Colombia has come so far in so many ways in terms of just what we think of as orthodox rule of law development. My guess is the space for corporations to be working with the AUC are lesser now than they were decades ago, and maybe would be even less in the future because of the hard work that Colombia has done on the ground to promote rule of law, transitional justice. So how do we think about not just the Chiquita case, but things like the FCPA, things like rule of law initiatives? How do those all fit together given the headwinds and the broader structural prescriptions that you suggest?
Thank you, Steve. First, I think, and I think you put it very clear, every single initiative is helpful, I think. Is helpful to bring corporations to respect human rights. Now, I think the fact that we have, for instance, the French law on business and human rights due diligence, the fact that victims found a way to bring cases here when we thought it was almost impossible against U.S. corporation. I think that single action really helps. However, my invitation is, okay, that's fine. I'm not criticizing that as such. What we need is to move a step forward, and is this all that we can do? Or can we think beyond that? And that's my invitation, to think beyond the global north, to think beyond those human rights due diligence legal initiatives in France, in Germany, the European Union. We still don't know if it will come to apply or not. But again, if you think about everything here, is about the global north telling what to do, how to do it. And I guess one way to do it is whether countries could work together, right? Whether, for instance, and tomorrow we have this conversation with Colombian justice that sits at the Colombian Constitutional Court, and she will tell us, for instance, how difficult it has been to enforce a judgment against Facebook, right? So real, powerful corporations do not care about judges in the global south at all. How are we going to change that? That's the kind of invitation, but I think everything here, every little helps, and we're moving perhaps, I hope, towards the right direction. Thank you, Steve. I think Erika. Oh.
Should I go, or I know Eric? Oh yeah. Oh.
Thank you, Professor Prieto-Ríos. It was a fantastic lecture. I enjoyed it very much. I have a question about the importance of the locus of where the enforcement is happening. So it might not be true, but it's a common view that the UN is a largely toothless organization. If that's the case, and given the Chiquita case where United States courts use doctrine that allowed them to enforce a tort claim against the Chiquita, why should we focus on putting our efforts towards advancing UN initiatives that you mentioned, the various initiatives such as the tribunal, when we could at the same time, or not at the same time, but the opportunity cost is or might be putting more effort into advancing people with more empathy for global South issues in global north jurisdictions. So like, in the US, in the UK, in France, these places. I wonder, like, what is the importance of particularly focusing efforts on the UN?
Thank you. Well, I think one of the aspects is that the two initiatives. First, the treaty, it's being negotiated under the umbrella of the United Nations, but that'll be an independent treaty if it happens to become to be ratified by enough countries. But the second initiative, maybe I put the United Nations, I use a United Nations picture. However, the idea is to have a treaty that creates this international treaty, right? Now, I think, for instance, international investment law has been very effective, super effective. If that's the case, can we think about a similar treaty, creating an international court that could actually impose binding actions on states and corporations? Maybe yes, we can believe that. And that's the paradox. Why it's so easy for us to enforce the international investment law and to find so difficult to enforce human rights? That's a paradox, and that's my invitation. Maybe I'm a dreamer, who knows, but it's an invitation to reflect. Thank you for your questions.
Thank you so much for this amazing lecture and just for your presence here and making us remember that we are part of the Americas, and I feel like that's incredibly important. Thinking about the Chiquita case and how that was very limited, but in that case, the courts did not, forego to forum nonconvenience and just send it away. So really the situation, we're thinking about holding U.S. corporations, responsible and finding them liable within the U.S. for their human rights abuses. How might we reconcile that, even as limited as the Chiquita case was, that there were some supports? Was it because the paramilitary group was a terrorist organization? Why did they even hear the case in Florida? And so perhaps it's even worse. And what should be done in that front of, I think the decolonial efforts are even more important, but what should be done with U.S. courts holding U.S. corporations liable?
Yeah, thank you, Jasmine. So I believe, again, this was very important for the families. This ruling, was justice for them. After so many years, they filed claims. The claims were rejected under the ATS. Then finally, a group of very smart lawyers who did their job and found this doctrine, they came up with this argument. And I believe here we have there is a difference in this case, and is that, in fact, Chiquita first pled guilty to the Department of Justice many years before. So, and that the AUC is a terrorist organization. So everything was in place to facilitate the ruling, right? Now, that's not always the case. And perhaps in other situations, maybe like victims, not only in Colombia, but in other parts of the world, might find it almost impossible to get justice in the United States. And then, once again, I'm not criticizing the judgment itself, it's just the whole structure. It shouldn't be like that, really. It shouldn't be necessary for victims to come here. They began this case in 2007. Justice was delivered on 2024. And can we, is it okay to rethink these? I think yes, we need to rethink the whole framework.
Hi, Enrique. Thank you so much for this paper and for your presence here, and especially the contribution that I know this will make to the business and human rights literature. So I have one question, but I have two comments and compliments. One is, you're completely correct about the conflict-affected areas approach of business and human rights. It is based on global north assumptions, and things like informality and high conflict were not the baseline of assumption for making a managerial approach to how do you manage and regulate human rights risks as opposed to risks to people on the ground. So thank you for that. And also you're pointing to conflicts that don't get a lot of attention. In the space, Ukraine gets a ton of attention, to a lesser extent, Gaza, Sudan, Colombia. So in your work, you're really surfacing a space that hasn't been explored sufficiently in this literature. And you're also emphasizing access to remedy, which goes to the hearts of rights that victims of abuses have. And the irony of this case in Florida, I'm with Jasmine. I think it's a tremendous victory. It's kind of amazing this didn't get thrown out of court as so many cases have in recent years. So I think there's perhaps something more to be learned from the transitory tort doctrine, because the ATS is dead in the water. But you ask us to envision and imagine more. And you say that we really can think hard about a treaty and a tribunal. If you look back, and you had a slide with Frans Fanon and Anthony Engie and others, we've been on this road before and it got to nowhere. So in the 1970s, when the Global South had a new economic order proposed, there was strong, powerful opposition, again, from the same actors that did not let this move forward. It's not clear to me that a new iteration and a new treaty will do much more either as a global treaty. So a thought for you, I know that there are people who say that Global South countries are negotiated bad deals, these bilateral investment treaties got you nothing. Why not incorporate some of these principles into bilateral investment treaties? Some states that hold resources that the global north needs may have more leverage than other states that do not. So do you think that there might be a piecemeal way of accomplishing what it is you want? I can envision an investment bilateral treaty that has a choice of forum clause that refers to a particular kind of arbitral body that would have expertise in human rights or the environment, or what it is you envision with the tribunal. I wasn't familiar with that, but would you be willing to think more creatively than just going to a UN instrument and having bilateral negotiations really point out the power asymmetry and have coordination that way?
Yeah, that's a very important question. I want to make a quick comment, and is indeed it's like if history repeats itself. After the coup d'etat on the 9/11 of 1973 in Chile, many countries from the Global South began campaigning for a treaty that could limit, or at least an international code that could create limitations in how corporations interact with countries in the Global South, and that later that initiative transformed into human rights and so on and so forth. So yes, we've been here before, but it really shows how important this is for countries in the Global South. Second, Colombia itself, I have had the possibility of advising the Colombian government, and Colombia has included human rights and environmental clauses in bilateral investment treaties. However, we have an example with the free trade agreement between Canada and Colombia, in which the arbitral tribunal dismissed the idea that the whole treaty intended to protect the environment and human rights, and it found Colombia international liable for the commission of an international wrongful act. So that's a problem. In international investment arbitration, we don't have precedent. There is no single court. We have many tribunals, and as such, it's very difficult to see or to foresee how a tribunal may decide a case, even if the treaty has a human rights or an environmental clause. So countries are doing that, but it does not protect them, and that's a problem. And that's a big challenge here. But I guess, again, the invitation is these were only two initiatives. There could be more, but we need to create awareness about what's happening, and to come together, those interested, to think about initiatives and how we can find opportunities for victims to find justice. I think, Jack, there are two questions, three.
Thank you so much, Professor. My question is with regards to your proposal for the International Tribunal, you'd mentioned this idea of, I guess, advancing epistemologies of the Global South. Is this not working?
But I can listen to you, yeah.
Thank you.
It's not
You'd
wor-
mentioned promoting or ensuring that epistemologies of the Global South kind of take front and center stage at this international tribunal. And I guess my question is, considering the heterogeneity of the Global South, how would you ensure, I guess, for each case that it does actually reflect the lived realities in every single country as opposed to the monolith of the Global South?
Well, yeah, it's a tough question. So, yeah, it's easy to just to write, difficult to think in reality. Okay, so I'll say the following, and is it for it to happen, it requires that the negotiation of the treaty creating this international tribunal really reflects direct conversations between Global South and Global North, but most importantly, bring like all those communities that are part of the Global South that are not usually part of the governments. Like in the Global South, most of the leaders are people that have graduated from universities in the US, in London, in France. So even the governments there do not understand what's happening there, right? So the only way is to make a process in which the treaty itself, because the treaty is the constitutive document, or will be the constitutive document for that court. So if in the process of negotiating these, you really create this space of different thoughts, different discussions, there could be something. And in fact, that's what has happened during the discussions of the Business and Human Rights Treaty. You have indigenous communities, you have like all those, not only governments participating, but stakeholders from civil society, from different parts of the world. And that's in fact what has molested so much the global north, that it feels like, wow, we know about individual rights. We don't understand what they are talking about collective property, and that has been the case. But I believe that could be a path forward. Am I being realistic or not? I don't know. I don't think so, but I want to try. It's an invitation to think.
It's interesting. That was my question. Is sort of a follow-up. I was wondering if you could comment a little bit on how united the global South is in terms of wanting this, and whether there's a serious danger of sort of defections, like they're in a prisoner's dilemma. Are there countries that and plus, there's some, it's hard for an American these days to criticize the leadership of any other country, but there are countries where the interest of the national leadership is not really focused on justice for the average person in the society. So I'm wondering, is a sort of a multilateral treaty really important in order to bring all these other countries around, as opposed to trying to do it in bilateral treaties among different countries with the countries that they have a lot of investment from?
Well, first, thank you, Jack, for reading my paper. I hope it improved from the first time you read it. Yeah. Second, the Global South has never, ever been totally united. The Global South has always been divided. Think about, I don't know if anyone is from Argentina here, I'm sorry, but President Milei, for instance. Now, having said that, we can look back at what has happened in the past, or what happened in the past. And there is the Bandung Conference of 1955, which ended up creating the G77, or the group of non-aligned countries. And although there were differences, like some of them were super right-wing, others were left-wing, at the end, the necessity of not getting aligned neither with the USSR or with the USA, so got all the countries together, and they saw, okay, it doesn't matter if I'm a super right guy, here I have people on the streets suffering, so we need to move beyond that. And maybe that's what, maybe there is an invitation. I mean, like, corporate power is everywhere. And all countries are being affected either positively or negatively. And then if that's the case, maybe that could trigger countries, not all, but some of them, to come together and rethink the whole structure. Maybe like what I think is this treaty that's under negotiation. Actually, the negotiations happened on the 12th of October, if I'm not wrong. But maybe this treaty is bringing states from the Global South together, even though they do not agree about economic policies or they disagree about many things. But the negative effects of corporate power are managing to bring them together to Geneva to discuss and perhaps to come up with a strategy. But again, could be impossible, but it's happening. I don't know, Jack, maybe we need to drink a beer and then think in more detail. Thank you so much.
So on the impossibility, Jack and I read the paper. We loved your work. I, have been a negative out to me the mines ban treaty. Everybody said that was impossible.
Yeah, and this is a treaty that it began in 2014 and is being led by Ecuador and Latin American countries, and then countries from Africa and Asia jump in, like joining these efforts. So maybe there is a possibility. Maybe I'm just a dreamer, but it's important to dream and to think beyond what is happening right now. Thank you so much.